Administrative law involves some of the most fascinating constitutional questions. Ordinarily, such cases involve conflicting interests between two branches of government. An executive action may conflict with a congressional enactment or a constitutional limitation, or an act of Congress may encroach on the constitutional role of the courts. But administrative law decisions often involve weighing the roles of all three branches of the federal government. Take, for instance, the 1985 case of Heckler versus Chaney. Several states used various combinations of powerful drugs to carry out capital punishment by lethal injection. The Federal Food and Drug Administration, or FDA, regulates how these controlled substances are used, but has never approved their use in executions. Leon Chaney and other death row inmates from Texas and Oklahoma petitioned the FDA to bring enforcement actions against the states. The inmates claimed that states using these drugs in lethal injections violated the Federal Food, Drug, and Cosmetic Act, which we'll call the FDCA. The FDA responded that it didn't have jurisdiction to review the use of controlled substances in lethal injections, and that even if it did, the agency elected not to do so. The inmates sued Secretary of Health and Human Services Margaret Heckler, seeking an order that the FDA begin enforcement proceedings against the states. The district court granted the FDA summary judgment, but the Court of Appeals reversed and ordered that the FDA begin an enforcement investigation. The FDA then petitioned the United States Supreme Court for review.